All right, welcome everyone. Today's Tuesday, February 13th, 2024. We have two voting lists before us. And if you look at voting list number 3, those are all of the bills that we intend to vote on, but are still under, there's still work groups assigned to them. So the work groups are continuing, but we intend to work on those, and those will be on the list on Thursday, assuming that the work groups are successful in reaching resolution on them. So we're going to switch over to voting list number 4, and we're going to start off with Senate Bill 4 with Jamie. We're just going to go straight down the list for council, so you can prepare yourselves.
Senate Bill 4 requires a commitment unit to include the name and telephone number of the lead victim services employee of the appropriate state's attorney's office in a notification given to a victim's representative, or a witness regarding the release of a defendant or child respondent. There are no amendments.
All right. Give you all a second to look over it. It's been motioned for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. Okay. All right. Next, we'll move on to, so Senate Bill 4 passes unanimously. And we're now move on to Senate Bill 19. Shamari.
Senate Bill 19 requires the district court within 60 days after the resolution of a failure to pay rent proceeding that did not result in a judgment of possession to shield all related court records. The district court may, on motion of a tenant and if specified requirements are met, shield all court records relating to a failure to pay rent proceeding that results in a judgment of possession. The bill also prohibits, with limited exceptions, a landlord from increasing rent solely because a judgment was entered against the tenant in a failure to pay rent action, and requires the judiciary to develop and publish a specified form to facilitate implementation. The bill's shielding provisions apply prospectively only and may not be applied or interpreted to have any effect on or application to any action initiated under 8401 of the Real Property Article before October 1st, 2024. The bill's provisions related to the development publication of a petition to shield form take effect August 1st, 2024. There is an amendment in your packets. This amendment deletes the provision that does not permit a landlord to increase rent solely because a judgment was entered against the tenant in a failure to pay rent action.
That's your whose amendment was that?
This was Senator West.
Senator West. Can we get Senator West, please?
Yeah, thank you, Mr. Chair. It was my amendment, and I believe the sponsor of the bill is accepting it as a friendly amendment.
Senator McKay.
Senator Sidnor, is this on the House side? Are we okay with that? Or yeah, because she and I had worked on something. I mean, this satisfies what I'm looking for, but I just didn't want to do an end around on the House.
No, they're fully aware.
Okay, with that, I move the amendment.
Second.
All right. Amendment's been adopted unanimously. The bill's before you as amended. Further discussion.
So the amendment allows the landlord to raise rents simply for the because the judgment was entered against the tenant, and so it just deletes that prohibition from the bill.
So
It leaves the status quo with the law.
Right.
Okay, got it.
It's a lot of shield now. Still shields.
Yes,
It still shields it.
that part is unchanged.
After 3.
So it's after a year of a judgment of possession, you can petition to shield.
So just to make sure we all understand, so if you're in a jurisdiction that has 3 rights of redemption in the course of a year, let's say you get the first one of the year, how long do you have to wait for? Let's say it's 3 months into the year, so you're March, and then you satisfy the judgment, you pay, you stay. So a year from March is when you can expunge that, or how many can you do in a year now?
Well, That is unchanged. You wouldn't be able to exercise the right of redemption if you have 3 within a year. And in Baltimore City, it's 4. And so let's say you have 4 over the course of a year. You'd have to wait a year after your last judgment of possession to be able to shield.
You have one. How quickly can you do?
A year,
You have to wait a year before you can expunge.
shield.
Shield it, sorry, make shield it, yeah. And you can use this exercise is multiple times, but you have to wait a year from the first judgment,
From the last judgment.
from the last judgment, yeah.
Correct.
Okay. All right, the bills before you amended, further discussion? Motions for favorable, it's been seconded, let's do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse. Senator Folden.
No.
Senator James.
Yes.
Senator Kelly. Yes. Senator McKay.
Yes.
Senator Carter.
Yes.
Chairman Smith.
Yes. The
He's
bill,
absent today.
bill passes
8-1.
8-1.
Could I add myself as co-sponsor on the previous bill, Senator Westpac?
That moves it from favorable to favorable with amendments.
Sure, that's fine.
Okay.
We're gonna pull, so we'll pull back up Senate Bill 4 just for purposes of a sponsor amendment. Is everyone okay with having Senator West added as a sponsor? Or co-sponsor?
Yeah, I know, right?
All right, Senator Carter wants to be on. I'll be on. All right, Senator James is on. Senator Sidnor is on.
Except Folden.
All right, is everyone okay with that? Okay,
What? You want to be on?
Senator McKay is on.
I've got Senator Carter, West, James, Sidnor, Smith, and McKay.
All right, is everyone okay with adopting the amendment?
And Folden.
And Folden. Oh my God. Yeah.
Now all the ball.
It's good. All right. All right, Senate Bill 4 passes unanimously with amendment.
Yeah.
All right, we're now gonna go down to Senate Bill 42. Josh.
Senate Bill 42 generally prohibits an adult who is present and directly supervising a minor from allowing the minor to ride a horse in specified areas unless the minor is wearing, properly secured, a helmet that meets or exceeds the standards of the American Society of Testing and Materials for protective headgear used in equestrian riding.
I got distracted reading an email about one of these work groups. Can we hold the bill until the next voting session, just so that we're sure it's absolutely identical to the House, so we don't have to go through this again?
Of course.
Thank you.
Senator Esther Hold. Senate Bill 42 is held. We'll now move on to Senate Bill 55.
Senate Bill 55 authorizes the MVA to issue a special disabled veteran registration plate to an individual who is between 50 and 99% service-connected disabled, as opposed to current law, which requires 100% disabled. You're right. With this 50 to 99, you would not automatically get the handicap placard, which you do with the 100% disabled.
Discussion? Motion for a favorable?
We did,
Oh,
I think
sorry.
we had a co-sponsor request from Senator James, I think.
Oh, sure, I'm sorry. Senator James, this should be added onto the bill. Is everyone okay? All right. Now, the bills before you as amended, motions for a favorable. Seconded. Is everyone okay being recorded in the affirmative? Okay, excellent. Senate Bill 55 passes unanimously with amendment. Now move on to Senate Bill 147.
Senate Bill 147 alters the annual reporting requirements for the Access to Counsel and Evictions program that is administered by the Maryland Legal Services Corporation. There's an amendment that sunsets the bill's provisions in 2027.
Senator West, that's your amendment, right?
Yes.
Senator West.
So this is a very simple bill that right now, the annual budget contains a notation requiring this report to be filed by the Maryland Legal Service Corp. This puts it in statute, so we don't have to keep putting that notation in the annual budget. The Maryland Legal Service Corporation came in and they said they sunset themselves, their funding in 2027. So they wanted this bill to also sunset, so they wouldn't have to keep making these reports if they lose their funding. And I said the amendment makes sense. So I move the amendment and then we'll move the bill.
All right. So motion to adopt the amendment's been seconded. Is everyone okay with the amendment being recorded? All right, now the bill's before you as amended. Further discussion. All right, motions for favorable with amendment. It's been seconded. Is everyone okay with being recorded in the affirmative? All right. Senate Bill 147 passes unanimously as amended. All right, we'll now go on to Senate Bill 149.
Senate Bill 149 authorizes a person who undertakes the towing or removal of a vehicle from a parking lot to notify the insurer of record electronically if that form of notice is agreed to by the tower and the insurer.
Discussion. All right, motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 149 passes unanimously. All right, now move on to Senate Bill 171.
Senate Bill 171 requires the landlord to accept financial assistance from the Office of Home Energy Programs within the Department of Human Services for the cost of utility service that a tenant is required to pay. A landlord must provide a tenant on request with utility service documentation necessary for OHEP to determine the tenant's eligibility for financial assistance as specified. The bill authorizes imposition of an administrative penalty for noncompliance. Penalty revenues accrue to the general fund. There is a sponsor amendment in your packets. That packet or that amendment strikes the bill in its entirety and instead adds gas and electric utility services to 8205.1 of the real property article, essentially requiring landlords to produce those documents, those utility bills when in the lease, payment of utility bills is paid by the landlord and the tenant has to pay. So essentially it simplifies the process so that tenants can request their utility bills and have the Office of Home Energy Programs provide them assistance if they qualify.
Senator McKay.
Thank you, Mr. Chair. I just have a question. So for buildings that have one bill, they're not divided up by the tenants. How does that apply? Because you're not conforming with the law saying that this is what the unit is actually had in natural gas for its heating. I mean, I don't know how it sounds like we're setting something up for a landlord to be in violation because the bill is for the whole unit, not, or the whole building, not the 5 units.
Right. So I think in that case, they would still have to provide under this the utility bill to the tenant and then
Right, but it's not a true number.
So what was the question? Can you say that again?
Sure.
Yeah.
So one could have a multi-unit house has 5 units in it.
Yeah.
One of the tenants have asked for energy assistance, which is no problem. But this bill is requiring the landlord to provide the utility bill for that unit. The problem is the utility bill, because it's one utility bill for the whole building. It's not actually conform to what is being requested. They can't give it to her.
well, I mean, I think they would have to provide that utility bill, and then the Office of Home Energy Assistance would make a determination as to how much assistance.
But they wouldn't be making a determination that the landlord was not in compliance with the law?
Well, the bill strikes any civil sanctions for not complying, but I do believe, just based on the language, that they would have to provide the utility bill to that tenant.
Okay.
Is that cumbersome? Or yeah, I don't know.
It's not cumbersome for somebody who accepts this and does this on a regular practice. First of all, I see no problem with it. I don't understand why a landlord wouldn't want to give somebody this, because it's helping to pay the rent. That by itself, giving a Columbia Gas bill, I pay $775 a month on the budget for the whole, but only one tenant applies for energy assistance. And so I have no problem giving the $775, but if they're calculating that bill on the 775, that's not a true amount of what that unit does. So I just don't,
You don't see.
I just don't want the landlord getting in trouble for not
Yeah.
providing said documentation.
Well, and it already exists in the context of sewer and water bills, which may not, would presumably fall under a similar.
Yeah, but
Problem.
sewer and water doesn't get grants from energy assistance. That's your electric and that's your gas. If you dead solar panels that put in for all of those, but your main water and sewer doesn't provide.
So how do they disaggregate it for like?
I would assume that they'll take the square footage of the building and divide it by whatever that unit is. So I'm not saying it needs to happen. All I'm doing is I just don't want landlords to have an extra step that now they're not in compliant because the bill that's supplied by Columbia Gas, not picking on them, does not go by individual units. And that's what this bill is asking for. Not a deal breaker. It's just,
No, that's good.
I need lots of landlords where I come from, because I'm never gonna have people come in and build multi-housing. It's just not, there's not a return on investment. So I need landlords. So I need to be able to show landlords that it's actually advantageous to get into the program. It's advantageous to get into the energy assistant program. I just don't need to make it harder for them when they can't supply what is actually being asked.
Got it.
That's all.
Back to Senator Augustine, asking if he wants to submit a friendly amendment to.
Yeah, I mean. So like in terms of being able to tell exactly what that specific unit usage is, I don't even know if that's possible, but we can check. I mean, we've got time. It's still early, so it's not going to hurt the bill if we ask him. So.
Not to be defined.
No, this is good.
It's a real
Let's
issue.
loop back with him then. All right. I mean, we'll hold the bill. Sorry, Senator Fulton. Yeah. I mean, if we,
I was just gonna say, it would make sense that you break it down by quarter of, how many units, if they're sharing the energy cost. And that be.
that's what he was saying. They probably do just by default, but I don't know. I have no idea. Well, let's hold him and ask him. It's not gonna hurt. We're voting on Thursday, so we could get an answer and we'll get it. We can still do it. It won't hurt the bill. These are good points. All right. Yeah. Can we, Senator?
On the flip side, those that are administering the funding, I actually look at it as a fair and not transparent, but a fair way to make sure that the dollars are following the particular tenant that actually is in need. I think that's an important issue that, that it doesn't, one tenant, let's say, because it says $775, they get the maximum amount, when the reality is there's only X amount of dollars in that program. And if we're giving one tenant more than they're supposed to get because we've created an issue that wasn't clear, then it's not. So
I'll text the sponsor as soon as we get off here and we'll get working on it. So, all right, we're going to hold Senate Bill 171 until Thursday. We'll now move on to Senate Bill 206. And we can go, Senator James, do you want to start off or do you want to? Shamar, we'll go, oh, yeah.
Senate Bill 206 establishes a specific procedure by which the governing body of a condominium may grant a lease in excess of 1 year or similar interest affecting the common elements of the condominium for the installation and use of leased clean energy equipment. There are two amendments in your packet. Senator James and Chairman Smith's amendments. Senator James's amendments strike the substantive provisions of the bill and instead vest the authority to grant leases in excess of a year on easements within the board of directors, who can take certain actions by a majority vote, but they have to have a meeting of the board held after 30 days notice to all unit owners and mortgagees of record. They cannot act until all unit owners and mortgagees shall be afforded a reasonable opportunity to present their views on the proposed easement. The easement, right-of-way, license, or similar interest shall contain the following provisions. The service or system shall be installed or affixed to the premises at no cost to the individual unit owners, other than charges normally paid for like services. The unit owners and council of unit owners shall be indemnified for any damage arising out of the installation. And the board of directors shall be provided the right to approve of the design for installation of the service or system in order to ensure that the installation conforms to any conditions which are reasonable to protect the safety, functioning, and appearance of the premises. You want to consider the amendment separately or together?
Does my amendment have that and then the
And so the Senator Smith's amendment.
you can say the number of the amendment.
Yes, amendment 163625 deletes the provision that allows for the council of unit owners to approve of leases in excess of a year by having 51% of the votes in the council, and still allows the board of directors to grant an easement with
So
majority vote.
essentially what this does, so the question was that whether you're gonna say, because right now you have to do 2/3 of all the unit folks. And this is for utilities, 2/3 of unit folks, and then or a simple majority of the board. Okay, with Senator James, correct me if I mischaracterize it. Would like to have that decision-making power kind of given to the board because the board's elected by the members. Which I agree with because it streamlines the process. It's great. The only problem with that, as far as the ancillary concern there, was that that triggers the requirement that you notify all of the mortgagees. And if you have a larger unit or development, then you could have different mortgage, like banks. People have lended from have been lent money from different banks. And so then if you had a lot of those banks, you'd have to go ahead and notify all those folks, and it sets off this process, which is laborious, which is kind of the purpose of the bill, is to kind of cut that red tape. So this is a happy medium where the board, which is representative of the members, elected by the members, vested with lots of responsibility, bring that down to 50% or simple majority, just like it is with the rest of the utilities, except for we don't require the notification of the mortgagees. That's what this amendment does. Senator James.
Thank you. If you all recall, that we did get into an animated discussion, and I will say to you that normally I read every bill and all the testimony in advance. And this is, of course, the one bill which I hadn't. And, Senator McKay brought up some good issues, Senator Folden, and I appreciate the chairman giving me 3 or 4 days. And I also spoke to the House sponsor. What I can tell you is sometimes bills like this come in, and because Montgomery County or Prince George's or Baltimore have so much more of this activity in any particular area, and they do talk to all the stakeholders in that area, and then they come up with a bill, and sometimes they make it statewide. But what I would ask the committee is to be sensitive to the fact that when you talk to all the stakeholders, no one in Harford County was spoken to. And I did spend quite a lot of time finding condominium owners trying to explain this, and some people that had managed, 50 of them. And they said, no one had spoken to them. They weren't aware of it. And I explained what we were going to do in terms of just keeping this with the board, very consistent with other utilities, and still major protections for unit owners to weigh in on the subject matter. So anyway, this I think is a good compromise for the counties that were not included in those stakeholder meetings. And then, you know, if we could always tweak it going forward, I think it keeps the integrity of why do people go to condominiums? Because they know that it takes about 2/3 of the owners to change the life, the building and the way it is to live there. That gives people a measure of continuity and protection about what they've bought into. But at the same time, the board of directors has historically, for a long time under this law, been allowed in those areas of utilities, which green energy is all really and is very much in line with that same concept, have been able to move faster with that 51% and then some notice to unit owners. So in a way, I really do think we improved the bill. I think we made it better. And hopefully the House will accept this. Thank you very much. I just wanted to give you that little overview. Thank you.
That's great. And also just the locals also maintain the code enforcement ability. So all that has to be up to spec in terms of the local qualifications and the inspection requirements and engineering requirements of the local jurisdictions. So then that I would move for the adoption of amendment 163-625/1. Second. All right. Now the bill's before you as amended. Motion for a favorable. With amendment. All right. We can do a roll call. And I'm going to come over and give Senator Folden a hug.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Folden,
Yes, as amended, thank you.
Senator James,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes, as amended.
Senator Carter,
Yes.
Chairman Smith.
Yes. All right. Senate Bill 206 passes unanimously as amended. We'll now move on to Senate Bill 251.
Senate Bill 251 is a departmental bill that updates obsolete references to facilities and positions within the Division of Pretrial Detention and Services in the Department of Public Safety and Correctional Services.
There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. Senate Bill 251 passes unanimously. All right, now we'll move on to Senate Bill 254.
Senate Bill 254 is a departmental bill that requires each motor vehicle insurer to participate in the MVA's online verification program. So if you recall from the bill hearing, there was broad agreement between the administration and the stakeholders that the effective date should be pushed back to January 1st, 2025. Also in your packet is a letter from Administrator Nizer committing to work with the insurers on the implementation, which was also a topic of some discussion at the bill hearing. My understanding is they're doing the letter, but we do need to do the effective date amendment.
So should we hold this then until
We have the letter from MVA and
is it in the bill file?
it is, yeah. Or it's in the voting packet.
Oh, wait, let me see. I didn't see it, sorry. Sorry, Senator Kelly.
My recollection from the hearing was that there was an implicit understanding that the letter would suffice. That
Got
was
it.
my-
Yeah,
what I
yeah.
got, yeah.
Okay. So I think that is right. So then no, they didn't. Yeah, you're right. So then can we adopt amendment 2231?
So we need to do it for the effective date.
Oh, you can just do inline?
Yeah.
Okay. Can you tell us where that goes?
Yeah, so it would be this page of the bill, which is just on page 2 and line 23, instead of October 1, 2024, it'd be January 1, 2025.
Is everyone okay with that amendment? Okay. So then this goes into the bill file for the legislative history and record. This is gonna go in there.
I just need a copy, yeah.
Okay, yeah. I'll give it to you.
Thanks.
Right. Now the bills before you as amended. Further discussion? Motions for favorable? Is everyone okay being recorded in the affirmative? All right. The Senate Bill 254 passes as amended unanimously. We'll now move on to Senate Bill 262.
Senate Bill 260. Senate Bill 262 authorizes the Secretary of State to suspend or waive the imposition or collection of late filing fees for charitable organizations and establish related regulations as specified. The bill establishes that a late fee may not be considered a delinquent account or debt requiring referral to the Central Collections Unit for collection purposes. The bill also establishes how the Secretary of State may cancel the registration of a charitable organization that fails to file specified reports, and how a charitable organization may request that Secretary of State reinstate a canceled registration.
At first, I thought this bill was much bigger than it actually is. Nothing. All right. Sorry. Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 262 passes unanimously. We'll now move on to Senate Bill 267.
Senate Bill 267 is a departmental bill that authorizes the MVA to and local health departments to access and issue copies of death certificates and to set and collect corresponding fees. There is an amendment in your packet. It's number 933822. It's just a technical amendment that adds some additional references to death certificates that were mistakenly omitted from the bill as drafted.
So I'm going to move. Okay, it's been seconded. So now the bill's before you as amended. All right. Motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 267 passes unanimously. We'll now move on to Senate Bill 270.
Senate Bill 270 alters provisions relating to the membership of and the terms of members appointed to adult public guardianship review boards.
All right. I know. We've all gone through this before, all of these bills before, but I want to make sure we're just reading it real quick. Brilliant. Okay. Got it. All right. Motion for favorable and seconded. Is everyone okay being recorded in the affirmative? Okay. Senate Bill 270 passes unanimously. We'll now move on to Senate Bill 275.
Senate Bill 275 is a departmental bill that authorizes the recipient of a Department of Defense next of kin lapel button to apply for special registration plates, similar to the recipient of a gold star. The bill also waives the one-time registration fee for the issuance of such special registration plates for both recipients of gold stars and next of kin lapel buttons. There is an amendment in your packet. It's number 223125. This just removes from the bill a requirement that the name and rank of the deceased service member appear on the plates.
That would have been weird. Okay, so amendment stopped it. Everyone's okay with that. Now the bill's before you as amended. Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Senate Bill 275 passes as amended unanimously. We'll now move on to Senate Bill 280.
Senate Bill 280 repeals the requirement that a notary public use a protest form prescribed by the comptroller. Right.
Created, the languages and the whole process is, moot and antiquated, and we're cleaning it up. Okay. I second whatever motion.
All right, motions for
Approve it.
favorable has been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 280 passes unanimously. We'll now move on to Senate Bill 282.
Senate Bill 282 is a departmental bill that repeals duplicative items from inclusion in GOCAP's annual report to the General Assembly on opioid use disorder treatment by individual local correctional facilities.
Right, that is not feasible.
No, we could hold this for like just till Thursday to have follow-up discussions. I did, because remember, we did talk to the chairman of Budget and Tax, but I've not followed up. So otherwise, it's just yeah. That's right, exactly right. Yeah. This bill is technically, I mean, it's just a technical bill, but there's a sidecar conversation we should continue to have, so I'll just hold it until Thursday. Is that okay? Okay. All right. All right, so Senate Bill 282 is, oh man, that looks good. Oh my God. Someone's cheating and eating lunch early, you know? All right, Senate Bill 282 is held. We're now gonna go to Senate Bill 285.
Senate Bill 285 is a departmental bill that repeals the fee that is required to be assessed by the MVA against an application for registration of a motor vehicle who had previously been refused due to an outstanding warrant.
All right,
Outdated provision.
they don't, you can explain more. I mean, yeah, they don't actually collect the fee
second.
anyway. It's good.
Mhm.
So according to the administration, this fee was originally instituted to cover their administrative costs in checking for a warrant, which according to them, they don't have that cost anymore due to technology upgrades.
All right, the bill's been. Motions for favorable and second. Is everyone okay being recorded in the affirmative? Okay, Senate Bill 285 passes unanimously. Hey. All right, we'll do Senate Bill 287. So Jamie, can we get Jamie?
Thank you.
Senate Bill 287 is a departmental bill that makes technical and procedural changes to MSP's licensing and certification processes. This is being done with an eye towards facilitating automated processing of applications and payments. There is an amendment that MSP requested, and there were some omissions in the drafting. So I've been in contact with House Counsel, and evidently the House Judiciary Committee is considering and working on the amendments to fix the language in the bill. So I would just recommend holding
hold it.
this until
Yeah.
that's ready.
Hold. Senate Bill 287 is on hold. All right, Senate Bill 348.
Oh, that is me. Senate Bill 348 provides that a person may not be denied the right to purchase, own, possess, or carry a firearm solely on the basis that the person is authorized to use medical cannabis under Title 36, Subtitle 3 of the Alcoholic Beverages and Cannabis article. There are no amendments.
I don't, other than would like to move the bill.
The bill.
All right, we've passed this bill like probably 5 times. All right, motions for there, second. Is everyone okay being recorded in the affirmative? Okay, next. All right, Senate Bill 379. That's Jamie.
Senate Bill 379 renames the Task Force to Study Crime Classification to instead be the Task Force to Study Crime Reclassification and Penalties. The bill also expands the membership of the task force and alters the duties of the task force. The task force must report its findings and recommendations to the Governor and General Assembly by December 31st, 2025. There are two amendments in your voting packet. The first amendment, Amendment 893-621/1, that's Amendment 893-621/1, is an amendment from Senator West, which would add MCASA to the task force.
Requested by MCASA. I'm happy to offer that as a friendly amendment. So I move the amendment.
Second it. Is everyone okay adopting the amendment? Do you want to go over, just real quick, read the current list of members now with the MCASA, please?
Right. So the current members of the task force are one member appointed by the chair of the Senate Judicial Proceedings Committee, one by the chair of the House Judiciary Committee, the Attorney General or the Attorney General's designee, the president of the Maryland States Attorneys Association or the president's designee, the public defender or designee, the executive director of the Maryland Network Against Domestic Violence or the executive director's designee, and the two being added by the bill would be the executive director of the Maryland Sentencing Commission or designee, and the executive director of the Governor's Office of Crime Prevention, Youth and Victim Services or designee. And the amendment would add MCASA or the executive director's designee.
Dumb question. Is this the new name for GoCap again? It's just the proper new name. Okay.
The new name for GoCap would be the Governor's Office of Crime Prevention and Policy, but
So it'll just, what,
it'll automatically change. But as far as the drafting goes for.
okay, got it. I was like, but the statute will be the same. Like, that'd be a cool new tool. Like, the statute automatically changes. All right, Senator Sidnor.
Quick question, for the Maryland Sentencing Commission, does it matter that it's not fully written out on criminal sentencing policy?
Let's see, Maryland Sentencing Commission or you know, that, let me double check on that. I think it's understood that they mean Dr. Soulier or his designee. But let me, just before the end of voting here, let me double check on the phrasing of that to see if that's okay.
Thank you.
So we can move to adopt the amendment. Is everyone okay? All right. Okay, got it. You got that?
Mhm.
All right, excellent. All right, and then I just want to do a sponsor amendment. I'd just like to hop on the bill. That's cool. Is everyone okay with that? Huh? Yes, but can I help? Yeah,
Okay.
all right.
And there's also
The task force language.
the task force
Yeah,
language. So
okay.
that's amendment 193-321/1. This is the same boilerplate.
Senator Carter, did you want to say
language
something?
that,
I'm
the
sorry.
committee's been adding to.
Sorry, Jamie, I'm sorry,
Sure.
Council. Senator Carter, do you want to say something? Oh, okay, sorry. Go ahead. Sorry.
So this is the same amendment language that the committee has been adding to task forces that it's been passing. It would provide that a member of the task force serves at the pleasure of the person who appointed the member, and would also require that the task force vote to adopt a code of conduct at its first meeting, because this is an existing task force, its first meeting on or after June 1st, 2024, which is the effective date of the bill.
Motion, moving the amendment. Second, all right, everyone's okay with moving the amendment. Now the bill's before you as amended. Motions for favorable. It's been with amendments. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. So Senate Bill 379 as amended passes unanimously.
And we're adding you, Mr. Chair, as a
Yes.
co-sponsor.
Yes, please. I mean, that's it, right? Is that it?
That's it.
All right, excellent. So we're gonna take let's take a 10.
Well, bill hearing start at 1.
Oh, actually, hey, we'll see you back here at 1 o'clock for bill hearings.